Okay, Assalamualaikum and good afternoon, students.
Afternoon, madam.
Yeah, good
Good afternoon,
afternoon.
madam.
Yeah. Okay, so I think we will start the class now. Okay, so we will continue with misconduct of employee. Yeah. Okay. Okay, so everyone is in a good condition. Okay, so here I can see chats replying my welcome for the class. Okay, thank you to all. Okay, so for the misconduct, we already learned about what is the definition of misconduct. Okay, then we got also one case for that. Okay, that it must be something to do with the employment contract. Okay, and if it is crime outside the employment, it can also be misconduct. The employee can be dismissed. Okay, then there's one case on the definition of misconduct, Holiday Inn versus Elizabeth Lee. Okay, and what is the provision under the employment law? Okay, that's the section 14, section 14 of the Employment Act, which talk about what the employer should do if there is any misconduct. Here, misconduct is not defined, so you have to relate to the case. So, misconduct must be inconsistent with the express or implied term of the service. Service here means the employment. Then the employer also have to conduct due inquiry. So due inquiry is what you're going to study in this class today. So only after due inquiry, the employer can dismiss without notice, downgrade the employee, or impose any other punishment. Okay, he can also suspend the wages, but not more than 2 weeks. Okay, I think you can get clues for your assignment here. Okay, so if the investigation, okay, shows that there's no misconduct, the employer have to return. Okay, so there's a provision here also. Okay, and what's the standard? Okay, the standard is on the reasonable ground. Okay, believing that the employee have conducted or committed misconduct. Okay, and there's a argument on the case also, which standard to be used if it is a criminal case. Okay, so if you allow the employee to continue to work after the employee has committed misconduct, then it will be condemnation from the employer, where the employer is considered to give forgiveness to the employee. Okay, so you must remember, as an employer, you must take action immediately when there's a misconduct by the employee. Okay, then what else we already learned? Okay, the types of or the what do you call the various category of misconduct. Okay, the aspects of misconduct, like single act. If the employee has committed only one act, so what is the circumstances? Okay, okay, or what is the um what will happen to the contract. So the employer also can dismiss the employee if the misconduct is very serious. This is for the single misconduct. We got similar misconduct, okay, which means you are repeating the same type of misconduct, or it can be past misconduct, okay, from the previous employer. Okay, it can be criminal misconduct. Okay, okay, we got also misconduct outside the employment. Okay, then a provocation of misconduct. Okay, so the aspects, there are few aspects that you have already seen. Okay, so kinds of misconduct is what type of misconduct the employee is actually doing. Okay, so I think I will leave this to the students to read because we already got cases. It can be more than this. Okay, so we will see how the wait, too long for this. Okay, so you will see what is the um domestic inquiry actually. Okay, so domestic inquiry actually comes from the word here, due inquiry. So due inquiry is where the employer have to conduct investigation or inquiry. Okay, so the word is due inquiry under section 14 of the Employment Act, which require a proper domestic inquiry, or in Malay, if you heard, siasatan dalaman, or domestic siasatan domestic. Okay, so the employer have to conduct a domestic inquiry before taking any disciplinary action or the punishment. You cannot impose any punishment without conducting a proper domestic inquiry. Okay, so the domestic inquiry here must fulfill the principle of natural justice. Okay, here this is under the common law where there's a two element of natural justice for this, which we call in Latin audi autem partem, which means that you have to give the employee right to be heard. Okay, you must give him the right to be heard. So right to be heard, even though it means in one sentence just right to be heard, but the contents is like giving the employee okay, the rules of fairness, giving him the fair hearing, giving notice of the case, what is the misconduct, giving the employee opportunity of being heard. That means he must able to defend his case. So he can bring his own witness, he can challenge the employer's witness. Okay, he can also produce other evidence. Okay, so that's what meant by right to be heard. And then after the whole process of the hearing done by the employer, okay, the employee must be given the right to mitigate. That means why he conducted the particular misconduct. Maybe if he's a cashier, maybe he says that he need money for his children. Okay, or it can be like he asks forgiveness because this is the first misconduct. Okay, so he must be given the right to mitigate. Okay, to explain why he want the punishment to be reduced. Okay, then after that he must be given the right to appeal. That means if the employer already given the punishment, okay, he can ask the employer to consider, okay, the punishment, okay, with giving the reasons. Okay, so that is right to appeal. Okay, so for this we will not study each of these, so you can just read the cases which is relevant to what do you call domestic inquiry, and because the employment, okay, um, the employment, okay, case is not um, very detailed on this particular um, um, right to be heard. That means it does not discuss every detail. Okay, so only that the court will ask whether the employee was given show cause letter, whether he was given opportunity to explain the reason why he have committed, or why he have committed, or maybe it's just a false accusation. That means he have not done. Somebody have just accuse him of doing things, maybe like stealing at the workplace, okay, or maybe like a sexual harassment. Actually, he have not done. So he can reply the show cause letter. Okay, normally when the employee have done something, a show cause letter is given. So he have to reply. That's what we call a reasonable notice of the case. Then he will reply before the actual hearing between the employer and also the witness, okay, and the panel. Okay, so here according to the case here, okay, Skypack International Sdn Bhd versus 4R Ting. Okay, the court says that in gist, the principle, as may be stated, the workman is being inquired into must have a reasonable notice of the case that he has to make. Okay, that means a reasonable notice. Just a notice is not like charge sheet. A notice saying that why you have committed or why you are absent for so many days. Okay, the employer have to give a proper notice. Okay, then he must have the reasonable opportunity of being heard. Okay, so he must able to call his defense. Okay, and then he must be able to face and also challenge the accuser, that means the employer, the witness, okay, and the evidence. Okay, after that, okay, there must be also a panel or a tribunal which is impartial, that means have no bias or no interest in the case. Okay, so that is what we call rule against bias, the panel. Okay, which in Latin nemo judex in quasa sua. That means the panel, okay, must not be a man, okay, who have a case on that. Okay, a man should not be a judge in his own cause. That means he must not have any interest in the case. Okay, because justice must not only done but seen to be done. Okay, that means you must be somebody who have no interest in the case. So the tribunal must be impartial. A person who is neither directly or indirectly shall not sit in the judgment in his own cause or that in which he has an interest. Okay, so can you roughly understand what is the principle of natural justice for the domestic inquiry now?
Yes, kind of.
Can okay, so no question. Okay, so if you can give an example, okay, how the panel can be partial, that means can have any interest in the case. Can anyone give example? How you are said that you have interest directly or indirectly in the case. Yes, anyone can give example? Okay, Amir says that um, the witness, okay, how the witness can have interest. Here, this is about the person who is going to be the judge, the panel itself, because here, even though it's stated as a judge, the panel will have at least a 3% or 2%, or it will not be more than 3. Okay, so the panel, okay, how the panel can be biased. Any example how the panel can be biased?
Maybe the panel has invested something on the employer.
Again,
The panel makes some investment to the employer's company. So when he sit in the panel, he will try to help the employer during the case.
the employee. You mean the employee is the one who have what have
Investment.
investment. Okay, okay. So it can be interest. Yes, he have any shares. Okay, maybe the person accused can be a director or maybe a personal executive in the company. Okay, so you want to take action. Okay, but you know that the employee okay have um, maybe given some shares to the company, so you must take someone who have no interest Okay, I think somebody here says about um relative. Okay, so you cannot ask the relative of the employee to be the panel also. Okay, so the one that Yi Ching give is like interest in money. Okay, this will be like interest where they have a relationship. Okay, so that can be also what you call interest. Okay, employer give money to employee who be okay, or you have given bribe to the panel. Okay, also cannot. Okay. Somebody says corruption. Okay, between the panel and the employee. Okay, so it can be also. Okay, so you cannot have any interest either monetary or maybe blood relationship. Okay, or maybe other reason. Okay, so the tribunal must be fair. Okay, fair tribunal. Okay, so you can understand here. Okay, so there's one case where the panel, okay, is a former employer of the employee. Okay, former. Okay, that means the employee have worked before with the one of the panel. Okay, so that also considered um unfair. Okay, so you must take someone who have no interest with the panel. Okay, or sorry, with the employee. Okay, so we got one old case, Surinder Singh Kanda versus Government of Malaya, where the court says that we hold the principle of natural justice have been violated and the domestic inquiry was defective. Okay, so the old cases says that if you do not meet the principle of justice, the domestic inquiry is defective. That means it's not a good um, domestic inquiry. Okay, and the employee can challenge at the court. Okay, so you can also read this case. Okay, so what actually the court says about the domestic inquiry. Okay, so the domestic inquiry cases, you can see there are few decision on that. Okay, the court says that if the domestic inquiry is not good, the employee can refer the matter to the court. When the matter been referred to the court, okay, the court hearing is also considered as a domestic inquiry. Okay, so um, because of that, I think employer, okay, they have to conduct a domestic inquiry. Okay, so if you do not conduct a proper domestic inquiry, the matter goes to the court, and the court says that your domestic inquiry is fatal, is not good. Okay, that means at the end the employer will end up paying compensation. Okay, so there's a spelling mistake, dilemma here. So can you all understand?
Yes, madam.
Hannah? Okay. Okay, about the punishment. Okay, so when the employer have conducted domestic inquiry, okay, the employer can choose any of the punishment here. Okay, so punishment is dismiss without notice, downgrade the employee, or impose any other punishment as just and fit, and where the punishment of suspension without wages is imposed, it shall not exceed a week, period of 2 weeks. So the employer can choose um, any of the three punishment. Okay, so you can dismiss, you can downgrade, or you can impose any punishment. So if you want to impose punishment, which is like suspension of wages, you must make sure that you give them at least 2 weeks of the salary. Okay, And Goodyear's case, Goodyear Malaysia Berhad case says that not all misconduct deserve dismissal, which has been described as a capital punishment. Okay, so the employer here should allow the workman to mitigate for a fair and reasonable decision to dismiss. Okay, so even though Section 14 says that the employee can be dismissed, but this case says that it's not a good punishment because the employer should consider a fair and reasonable decision. Okay, so as an employer, you have to take into account like what are the past record of good service. Okay, what are the their good service. That means what they have done for the improvement of the company. Okay, and whether the management own action which contributed to the misconduct, like provocation from the management. Okay, how long they have worked with the company, the length of service and the quality of service, or if they have won any past service award. So you have to consider all these before you can punish because when you dismiss an employee, okay, they are going to suffer. They got no job and they have to wait for maybe months or a year to get a good job. Okay. So another case says that in determining reasonableness of employer's decision to dismiss, the proper test is not what the policy of the employer was, but was what was the reaction of the reasonable employer would do in the circumstances. Okay, so you must be a reasonable employer. Okay, whether in the particular circumstances you will dismiss the employee. Not. Okay, let's say accountant who stole checks from the company, and then he have regret, and then he try to pay off by installment. Okay, so you have to consider. Okay, maybe some employee have been disobedient to the employer because they are under pressure. Okay, or maybe they are very stressed at the workplace. So as an employer, you must be a reasonable employer before you could take an action to dismiss the employee. Okay, so that's what has been decided in Chartered Bank versus National Union of Bank Employees. Okay. Okay, so what are the procedures if the employee has been dismissed? Okay, so even though you have conducted domestic inquiry, you think the employee should be dismissed. Okay, so once dismissed, the employee can file action against the employer. Okay, so the procedure is in section 20, section 20, subsection 1 to 6. Okay, that means let's say Ahmad have stole some stationery at the company. Okay, maybe he have been doing that for the past 2 months. Okay, the employer caught by CCTV. Okay, so the Ahmad was given a opportunity of domestic inquiry and he was dismissed. Okay, so Ahmad can file against the company for dismissal. Okay, saying that actually he took the CCTV shows that he took, but he took for his work. That means he used at the office, or he used for the meetings, the stationery. Okay, so he said that the dismissal was unfair. Okay, so he was not allowed to bring witness, let's say in that particular case, because the company says that they already got evidence by CCTV, that's enough. So Ahmad was not given the opportunity to bring the witness. Okay, so what Ahmad can do is that Ahmad go to which department to file the reinstatement? Can anyone let me know for reinstatement?
Sorry,
Yes.
madam, can you repeat again?
Which department Ahmad when he was dismissed, he was not happy, which department he have to go for to file the case against the
The
employer.
industrial relation department, right?
Yes, industrial relation department. So he goes to the department, okay, or IR department, without says that, okay. So you actually the form, if you have seen through the Employment Industrial Relation Act, there's one form where he can file for reinstatement. Okay, reinstatement, that means he wants the job back. Okay, so if you want to file the case, which we call actually reinstatement, okay, or representation for reinstatement, okay, is where the employee goes to the department and fill in the form saying that he want the job back. Okay, so it's not that you want to claim for compensation, you want the job, because the word used in subsection 1 is that you want the former job, okay, reinstatement to the former job. Okay, so he have only 60 days, so he have to decide whether he wants to go to the department to file the case or not, to file the representation. So you got only 60 days to file the representation. Okay, so the officer there will call both of the parties, the employer and him, to negotiate and also to settle the matter. Okay, so if there's no outcome in that particular meeting between the employer and the employee, okay, in the industrial relation department, okay, so the matter will be going to the Director General, where the Director General will involve in this matter, okay, and he try to settle the matter. If the matter cannot be settled, he will refer the matter to the Minister, and if still cannot be settled, the matter will be referred to the court. Okay, so the process is like that, okay. Okay, so can you understand the procedure here? Is under subsection 1 to 6. Okay, so you have to go to the department. The department will have meeting between the employee and the employer. You cannot be settled, the Director General will involve and he try to settle. You see, there's so many parties. If the matter cannot be settled, they will refer to the minister. If the minister cannot settle, then only the matter goes to the court. Okay, so department, then who? Second, who is the person who is in charge there?
Employer and employee.
Yeah, first is employer, the department, the employer, employee. Okay, if cannot be settled, it goes to who will involve?
The Director General, right?
Yeah, the Director General. Then who will involve?
The Minister.
Yeah, after the minister, the matter will go to the court. So many stages. So after the amendment, the employee have the amendment means pindaan. I'm not sure when it will be enforced. The matter, that means the employee can fast track the matter to the court. Okay, so the current procedure is under section 20, subsection 1, where you go according to the stages. Okay, only the minister have the right to refer the matter to the court. Okay, so that's the procedure under section 20, subsection 1 to 6. Okay, who asked me if the employee claim wages? No, if you want to claim only for wages, I'm not sure what do you mean by wages here. When he was dismissed, if you want to claim for wages, okay, in the representation you will if there's no no reinstatement to the former job, okay, the court will give for the back wages. Back wages means gaji tertunggak. All those will be given by the court. Okay, the back wages, the compensation. Okay, so those are the things that the court will give. Okay, so is it clear? Okay. Okay, so if you have time, please Google a case. Okay, So you can see how the court calculate. That means if you work for 10 years, okay, you do not get a new job. Okay, from the date you be dismissed, okay, until the hearing, you can be given back wages, okay, but maximum, okay, according to the second schedule. I think I already repeated this in dismissal, the procedure. Okay, the different type of dismissal. I think I already repeated. Okay, so according to the second schedule of the Industrialization Act, okay, back wages is limited to 24 months now. Okay, okay. So do you have any question?
I don't have questions, madam.
Okay, thank you. So we'll go to the next topic. Okay. So I stop here for the dismissal. Okay. Then I think I already given you one case on the let me check whether I already given you a case now. Okay. So just 5 minute break. Okay, so okay, so the case that I showed you all before, can you all hear me? No, Hafiza? Okay, yeah, okay, thank you. Okay, about Bawazir, okay, thank you. Okay, so this is we use the same cases. So if you want, you can also search other cases. So where the employee was dismissed. So from the date of dismissal, okay, here, according to this case, you can see here he was dismissed in 2014, 10 of November, okay, and the hearing completed in 2016, okay, so it's more than 2 years, okay, so under the second schedule, okay, before this there was guideline. So after the amendment, okay, we refer to the amendment was made in 2012. So we can use the second schedule. The second schedule of the Industrial Relation Act says that it is limited to 24 months. Okay, so even though it's more than 2 years, but the court can only grant for 24 months. And that means when he was dismissed until the case was heard, is more than 2 years, so you can get for 24 months. So here 8,000 is the employee's salary. Okay, the salary times by 24 months. So this is amount of the damages, because in this case he was not reinstated, okay, so he cannot get his former job back. Okay, 10% is where post dismissal earning, that means after he was dismissed he got a job somewhere else, so the court has reduced 10%. Okay, then for each year of service, you also will get compensation, okay, because you cannot be reinstated, okay. So if you work longer with the employer, okay, let's say you work for 10 years, so you will get for 10 years. That means for each year, you get 1 month salary, okay. So because the employee has just worked for 1 year. Okay, he was appointed in 2013 to 2014. 13 to 14 is 1 year. So he get back wages for 1 year. That means 1 month salary. If you work for 10 years, you get how many months salary? 10 months salary. Yeah. Okay. 10 months salary. Yeah. Okay. So, okay. Both of you. Thank you. So here you can see the amount of the compensation. This is where the employee cannot be reinstated. Reinstate means to the former job. So if he's an accountant, he will be going to the same office, okay, and also be working at the same place with the same position. Okay, so in this case, there's no reinstatement. He will be given compensation. In lieu means instead. This is a Latin word, instead of reinstatement. Okay, so I think if you read more cases, you will understand how the calculation is made. Okay, so we already completed this topic. Let us move to another topic today. Yeah? Okay, I just want to ask, okay, do you want to continue with the um, class, or you want me to stop here? Our next topic will be on trade union.
I'm okay with either way.
Okay, so I will give you I will give you some introduction on the trade union. Okay. Okay, so maybe some of you or maybe all of you have heard about trade unions. Okay, so our topic today will be on trade union. Okay, so do you know why employees or workmen like to join trade unions? Okay, so if you anyone can give me a reason why?
The most that we heard of is to protect their right.
Yeah, really, yeah. Okay. So if you have trade union, okay, the union leader can protect you and also can get a better terms and condition from the employer. Okay, so that is to ensure the employees' right being protected. So they will get better terms and condition. That means when there's a more members or there's a collective agreement between the members, okay, they can go to the employer and demand for better terms and condition. Okay, so but that way it will improve their economic situation where they get a better pay and they can improve their life. Okay, and another reason is they can show solidarity. Okay, where the fellow workers will be protected. That means they have the leader and they have the follower there. Okay, I think those who are learning industrial relation would know much because they have different theory for that. Okay, so we will look from the law or legal point. Okay, so the right to form and join trade union has been mentioned in the Industrial Relation Act. So now you must know which act to refer also. There's only I think one provision under the Employment Act. Okay, so other than that is in the Industrial Relation Act and also the Trade Union Act. So for this topic, you will be referring to Employment Act, Industrial Relation Act, and also Trade Union Act. Okay. So Section 5, okay, says that the employer or trade union of the employer or any person on behalf of the employer, that means the agent of the employer or the trade union of the employer, okay, um, cannot impose a condition in the contract of employment which can restrain the right of a person who is a party to the contract to join a trade union, okay, or to continue his membership, okay, in a trade union. Okay, so you cannot restrain a person from joining and also to be a member in a trade union. Okay, you cannot refuse to employ a person on the ground that he's a member or not member of the trade union or maybe as an officer of the trade union, or you cannot also discriminate. That means you cannot be biased to a person who is a member or officer of the trade union in regard to the employment, promotion, or maybe you want to impose any condition of employment or working on that particular member or officer. Okay, and then under Section 7, the employee also have right not to be a member of the trade union. Okay, so the employees cannot be forced or the workmen cannot be forced to join a union. Okay, so under the Malaysian law, Section 5 give protection to the employee against any act from the employer, okay, prohibiting the employee to employ or to discriminate, okay, or to impose any condition in the employment because he's a member or maybe he's an officer of a trade union, okay. And at the same time, the employee also have the right not to join the trade union, okay. That is under section 7. Okay, so you can see the right to form and join the union. Okay, if he's under a temporary employment, okay, so if there's any trade union in the company, he can join, okay. It doesn't matter, okay. He can be a member in the uh, trade union in the particular company, yeah. Okay, I think that is here, okay. So what is a trade union? Okay, so trade union is a association or combination of workmen or employers. So you must remember, not only the workmen have trade union, but the employer also have a trade union. Okay, so um, they can be a member of the trade union. Okay, so trade union is a association or combination. Okay, that means it cannot be one person, it must be in a group. Okay, where the trade union can be with the place of employment in West Malaysia, Sabah or Sarawak. You can see that it's not Malaysia straight away, but according to the region. Okay, West Malaysia, Sabah or Sarawak. Okay, so the association can be within a particular establishment or industry or trade or occupation or similar, a trade, occupation or industry. So if you want to be a member of a trade union, you must join the similar trade. Okay, if you are a nurse, you must join the trade union of nurse. If you are a teacher, you must join the trade union of teacher. You cannot join whatever trade union you like. Okay, it must be within the similar trade, occupation, industry, uh, um, or whatever. Okay, establishment. Okay. So it can be temporary or permanent. Okay, it doesn't matter your work is temporary or permanent. Okay, but the trade union must have at least one or more of the following objective. Okay, so the trade union must can be an association or combination of workmen. Okay, for any particular industry. Okay, where it must be within the similar trade, occupation or industry, whether it's a permanent or temporary, but it must have one or more of the objective. Okay. Okay, what is the objective? Why you want to form a trade union? You must have any of the reason here. The objective must be one of here. Huh? Okay, one or more. Okay, one or more. Okay, where the trade union have regulation of relation between workman, employer for the purpose of promoting good industrial relationship. Okay, between the employer and workman or to improve the condition, working condition or economic or social status or to increase the productivity. Okay, so I think the first one is one that the trade union want to reform. Okay, then the other here between the relationship between the employer and employer, workman and workman. Okay, or it can be also for the purpose of representation of the workmen for any trade dispute or conducting or dealing with the trade dispute, okay, or any other matter, or for the of promotion of financing strike, lockout, okay, in the industry that they are the member, okay. So it can be any of the reason here, okay. So you want to establish or you want to form trade union, it must fall under any of these one or more reason or objective, okay. That means you cannot simply form, you must have the purpose why, of course. You want to promote, okay, or you want to for the better terms and condition, you want to represent the employee, okay, for any industrial dispute. So you must have your what you call your constitution. Okay, so there's also a constitution sample in the Trade Union Act. Okay, so the trade union, okay, are given 1 month, okay, from the establishment. That means when they are formed, they have 1 month, okay, to register. Okay, so the registration under Section 8, this is under the Trade Union Act. They must register within 1 month. Okay, if they do not register, okay, the trade union is unlawful. Okay, they cannot take um, uh, any partner. Okay, they cannot take part in the trade dispute promotion or to organize any trade dispute. Okay, and the fund must be disposed. Okay, and no person shall take part in the management or act on behalf of the union. Okay, so your trade union must be registered, but you got 1 month to register. Okay, so once it's registered, you must apply to your employer for recognition. Okay, so the recognition process is under the Industrial Relation Act. Okay, that means you have to submit your application to the employer. The employer will consider whether to give recognition or not. Okay, so again, the trade union, when there is a dispute, the trade union will refer the matter to the Industrial Relation Department, where the Director General involved. Then the matter will be referred to the minister, okay, for the settlement. Okay, so um, the procedure for recognition is a bit long. I do not want to go through that. Okay, so if you want to register, okay, these are the things that you must have. You must have at least 7 members. Okay, registration is under Section 10. There's a condition: 7 members must sign the application form. Okay, and then you must give a fee. Okay, and you must have your rules on the trade union that you're going to form. That means you must have the name, you must have the memorandum. What are your rules? Okay, on the trade union. Okay, it's like a company. Okay, you must have the memorandum. Okay, that means your objective. Okay, what you want to do under the um, trade union, why you want to form, and what are your things that you want to do. Okay, so the statement must have the name, occupation, address of the members. Okay, who are the um, officers. Okay, and then you must also have the address of the head office. Okay, then the title, age, address of the members and also the officer here. Okay, so you can select now who are the officers or the secretary for your trade union. Okay, so if you already registered the trade union, if you want to ask for recognition, okay, during the recognition process from the employer, you cannot launch any strike, any lockout. Okay, so it's not allowed. Okay, the employer cannot, is prohibited from lockout against the employee or terminate the service of the employee if there's any dispute, because some employer do not like trade union. Okay, suddenly they are not in good terms. Okay, they want to launch um lockout. You cannot do that. The lockout is to close the business place. The employer want to close his business place. Okay, we study more what is lockout later. Okay, so once you file the application for the registration, okay, the Director General of the Trade Union, here is the Director General of the Trade Union, he may consider your application. Okay, so of course, when there's an application, the Director General will consider the application. He may refuse or may grant for the registration. Okay, so he have the right. So he may refuse to register if he's satisfied there's another trade union can represent the workers in the particular industry, like teaching profession. If you already have one trade union, okay, maybe a trade union has been formed in 1970, and now you want to register one more trade union of for teachers again in 2020, you cannot do so, because there's already one trade union, okay, for the interest of the particular teachers, okay, unless you can show that there's a you mean to protect another group of teachers, okay. If not, the director general may refuse to register the trade union, okay, if he's satisfied that there is in existence a trade union representing the workers in the particular industry or trade, okay, and not in the interest of the workman, okay. So you cannot, like, anytime you want, you want to register, cannot. You must join the same um, uh, industry or the profession, okay. Okay, so how the director general may refuse, okay. First is that, okay, if he's satisfied that there's a trade union representing the particular group, can refuse, or he says that the particular trade union is not for the interest of the workmen, okay, and that there's another trade union in respect of that, okay. This is the first one that already explained, okay. um, Under subsection 3, there's more reason here. The Director General may refuse to register a trade union if he is in the opinion that the trade union is to be used for unlawful purpose or contrary to or inconsistent with the object of rules. Okay, so this is the Director General. He must give reason also. Or any of the object of the trade union is unlawful, because we have to send the memorandum for registration. So if you look at the objective is not uh, lawful, okay, is unlawful, then he can reject. Or he is not satisfied the trade union is has um, complied with the act and also with the regulation, okay, and he is satisfied that the object and rules and constitution of the trade union is conflict with any provision of the trade union or the regulation. So here is where it's unlawful. B, C, and D. You have not, is unlawful, or you have not followed the rules on the registration or the law on the trade union. Okay. So a trade union must be registered. Okay. Or it can be also the name of the trade union. Okay. You cannot use the same name which is identical. Okay. If it is identical, you cannot. Like students, you can have the same name, but companies, you cannot have same name. Or trade union also, you cannot have same name. Okay. So you must remember that if you have same name, it can deceive the public or the members of either trade union. Okay. Okay, so E is on the name of the trade union. And the last one is where the Director General himself, in his opinion, the trade union, okay, should change the name. That can be accepted. Everything is okay, but only the name. There's something wrong with the name. So the Director General says that, okay, if you alter the name, he will accept. Okay, it can be in that way also. Okay. So once it is registered, okay, no other trade union, okay, can claim under the same class of the employee for 3 years. Okay, so this is where the employee, okay, already got the recognition. Okay, so the trade union, okay, another trade union cannot claim for the same class. Okay, so the recognition can be rejected. Okay, um, here the union cannot make any claim for a period of 3 months, because sometimes, there's a few application for recognition. Okay. So if there's one class already given the recognition, you cannot again ask for the particular class or particular group of the workmen. Okay. So if it is rejected by the Director General, you have to wait for 3 months and send a new application. So this is under section 11. Okay, so any questions so far?
No
Maybe
questions, madam.
I can go 2 more slides, because it's more than 40 pages, 40 slides. Okay, so a trade union, even though it's registered, okay, you can also the certificate, okay, once it's registered, a certificate will be given. The certificate can be cancelled also. Okay, it can be also withdrawn. Okay, so how? Okay, at first is where the trade union requests the trade union to be dissolved. Okay, because the trade union do not want to protect a particular group of employee. Okay, they want to dissolve. Dissolve means dibubarkan. Okay, or here the Director General is satisfied. Okay, it's either the trade union themselves ask the union to be cancelled or dissolved, or the Director General of the trade union is the one who asked the trade union to be cancelled. Okay, on the following reason. The certificate is obtained by fraud. That means you have done any fraud or mistake when you want to apply for registration. Okay, or the object or the rules of the trade union is unlawful, or the constitution or the executive is unlawful, or the union is used or likely to be used for unlawful purpose, or the union has contravened any of the provision, or the fund has been expended for unlawful manner, or the union ceased to exist. So this is for the Director General to cancel the registration. Okay, so the registration can be cancelled by the trade union itself or by the Director General on this reason. 1, 2, 3, 4, 5, 6, 7 reason. Okay. So any question? Yes, any question, students? Or maybe we can stop here if you okay, somebody is asking. Let me check. Is the chairman can use the money? Okay. So we will look at the money. The money is what we call as the fund. Okay, I think that will be later at the end of this topic. Because to be a member, every month you must give your subscription. Okay, you run. Okay, to be a member. That means I'm not sure. Depends on the trade union how much you must to be a member every month. Okay, the employer will deduct the salary of the employee. Okay, and give it to the trade union fund, and the fund will be kept by the the money will be kept by the fund for certain particular purposes. Okay, so I think that will be towards the end of the this topic here. Okay, there's a rule to use the money. Okay. Okay, so the money cannot be used as you like. Okay, you must use for the purpose of, and also for the interest of the members. Okay, so that will be towards the end of the this particular topic. Okay, maybe next class. Okay. Then Amir here asks, can you explain about the punishment about suspension of wages? I think suspension of wages is the previous topic under um, what do you call, under misconduct. Okay. For misconduct, the employer can suspend wages for 2 weeks only. Okay, you look at provision section 14 of the Employment Act. Okay, I think the section is very clear. The employer, for investigation purpose, can suspend the wages only for 2 weeks. Okay, so read the section properly. Okay, and if you find that the investigation does not show any misconduct done by the particular employee, the employer must refund the 2 weeks salary that he already suspended. Okay, Amir? Any other question? Okay, can employee on part-time service can join the trade union, can, because it can be permanent or temporary. Temporary means part-time. Okay. Can the claimant claim for reinstatement at industrial? Of course, section 20 subsection 1 is for reinstatement. Please read the section properly. Okay, if you look, that's why I say that you must have the act with you, because during the previous lecture on dismissal, I already gone through the sections. That's why for this class, I do not want to repeat again. I think it's under the topic of dismissal, the different type of dismissal. Okay, I already mentioned section 20, subsection 1 to 6. So if you want to know further, you have to look at the Industrial Relation Act. Okay, so Industrial Relation Act says that the employee, okay, can file reinstatement for the at the Industrial Relation Department within 60 days. It does not say Industrial Relation Department, but all matters regarding reinstatement must go to Industrial Relation Department. Okay. No, you claim for reinstatement. The court will decide whether to give you reinstatement. Reinstatement means to go back to your former job. You get back your job. Okay. So when the matter goes to the court will decide, okay, to give you the former job or not to give you a former job. Okay. Let's say in case of sexual harassment, you see that the court do not want to give reinstatement because the harasser is at the company. Okay, so the court will give um, uh, compensation in lieu of reinstatement, the one that I show you just now. Okay, every year service, 1 month salary. Okay, so that's why you have to look at the cases, and the cases are already given you just now. What um, uh, compensation in lieu of reinstatement. Okay, where is it? I can close this one. Okay, I think where is the case? Hmm. Wait, I cannot close back this one. Okay. Okay, so bad wages is here. Okay, can your Amir, can you look at this? Hello, students?
Yes, we can see it.
Yes. So here is where you cannot claim for bad wages. The court will decide whether to give bad wages, okay, to give less of the bad wages, or to give a compensation in lieu of reinstatement. The court will decide. Okay, the court, because if you want to go to the industrial department, you must go for reinstatement. You want the job. Okay, it's not that you want the money, compensation. The court will decide to give you your job, maybe plus the compensation, or maybe there's no reinstatement, give you compensation, bad wages, and also compensation in lieu of reinstatement. Okay, so the court will decide on this. Okay, so when you read the case, you take a simple case, like this case is so many pages. Okay, take simple cases where you can read from the beginning to the end, to see how the court decide on on dismissal. Okay. Any other question, students? If there's no question, I want to end the class.
No, madam.
No,
Okay,
madam.
So I hope that you will finish up your assignment, because another assignment 3 will be coming very soon. Okay. If you already completed, you can send, and make sure that your answer, okay, um, um, do not overlap. Okay, you got question 1, question 2, do not overlap the um, answer. Okay, any question, exam question will not give you the same answer. Okay, that means if there will be something wrong. Okay, I already upload the notes on collective agreement, and also your on trade union. So please read before you finalize your issues. Okay, because I see some issues already those who check. Okay, already left out. I don't want to repeat the issue for you. I don't want to mention. I only will say whether it's like okay or not only. Okay, I will not give you a definite answer. You have to think about the question. If not, everyone will. I cannot like make sure that you can get the total mark. I cannot, because you have to prepare the answer. Okay, so make sure that you got the correct issue. Okay, by reading the notes, or maybe making reference to other sources. Okay. Okay, students.
Okay, madam.
Okay,
Okay.
madam.
Okay. Thank you.
Madam.
Not sure the attendance is there now. Okay, I do it manually lah, for those who have not. Who else? Okay, thank you.